Mr. Mears, you may, well, go ahead. May proceed, Mr. Mears.
Good afternoon. I'm always struck when I come over and argue after someone else how I can somehow be presenting something entirely different. That I'm here today on behalf of Lloyd Aschbrenner. The facts are quite simple, that Lloyd was a sex offender who was convicted of his sex offense in 2007, and that in 2009, the Iowa legislature substantially rewrote the sex offender registry statute and added a provision with regard to internet identifiers. Sex offenders were required to keep the sheriff informed of internet identifiers, and that whatever that meant. And if you had a change in your internet identifiers, you had to update the sheriff within 5 business days. In 2017, that Lloyd was prosecuted for not telling the sheriff about a Facebook page. Remarkably, I've had 3 or 4 clients who have run afoul of Facebook disclosure in the world of sex offender registry. I think perhaps that's because it's kind of easy for the sheriff to check. The sheriff just goes and has somebody plug in all the names of the sex offender registrants in that county and sees if anybody shows up on Facebook. That at least in some cases, people actually use their own name. That Mr. Aschbrenner was prosecuted. In the district court, we raised 2 complaints and a motion to dismiss. One was based on the First Amendment and the recent unanimous United States Supreme Court case in the Packingham case. Sex offenders, according to the United States Supreme Court, had a constitutional right, essentially, to use social media.
But in that case, wasn't a lot different factually, and then they were banned or barred from using the. And here, he doesn't even have to disclose his password, just the name he's using.
And that's very different. And that Packingham said that complete prohibitions were bad. And the problem under the First Amendment is that the law is that there is, in fact, a chilling effect if, in fact, you have required disclosure. At the district court level, we raised the First Amendment claim. We also raised the claim based on ex post facto, that the claim was not based on ex post facto, that the state was not able to do this at all, but they couldn't do this in 2009 and extend it backwards to someone who had committed their offense before that. So the 2 issues in front of this court that are, first of all, whether or not there is a First Amendment violation based on essentially the requirement that sex offender registrants have to maintain a current list of everything that is in your internet identifiers. I want to talk about that first, and I think the place to start is exactly what's covered. Everybody essentially understands email address, Facebook, social media, Twitter. Okay, those 3 or 4. But that's not what the statute says, and the statute doesn't stop there. It's any or other designation, moniker used for self-identification during internet communication or posting, including all designations for purposes of routing or self-identification. And that what you have to do is I agree it doesn't cover passwords. There actually were a few states about 10 years ago that actually required people to give out their passwords, and I haven't seen that.
Do we need to decide anything more than whether he can be charged and whether we can affirm his conviction for failing to disclose his Facebook account? Do we need to worry about what about somebody's Netflix account or something else?
Well, that's the beauty of the First Amendment. That is, the First Amendment has historically, and this court has affirmed the principle that when you're talking about the First Amendment, there is this principle of overbreadth, which is that Mr. Aschbrenner, who could potentially, with a narrowly drawn statute, be required to disclose a Facebook account, that if the statute is overbroad, he can assert that. And that in virtually all of the cases that have considered this around the country, and it seems like
Could we interpret the statute to avoid a constitutional problem and interpret it, for example, to just refer to where the offender is putting information out as opposed to just getting Netflix movie streaming?
well,
If they're posting on Facebook, for example.
You have some ability to interpret a statute and narrowly draw it and potentially avoid constitutional claims. But in the context of the First Amendment, I suggest that's probably, you can't do that quite as much in the context of a First Amendment challenge because of the chilling effect that is recognized by the overbreadth. The other thing is, okay, put aside for Facebook, what about your Amazon account? That in preparing just today, for example, and I have to admit that I had some enjoyment in writing the brief and being able to ever use the term Hy-Vee fuel saver as part of my brief. I was trying to make a list of all of the internet identifiers that I would have. And that just today, for example, first thing I got up this morning, I had a connection from a listserv with the State Public Defender's Office, which was notifying me that about this new Third Circuit case that I mentioned this morning, that I have a login and an identifier for that State Public Defender blog. That
Mr. Sloven says it only applies if they're used for the purpose of routing or self-identification in internet communications or posting. So if you're just using the username to access a service or to read something or acquire information, the way like I use my New York Times account or something like that, but I don't use it to post anything, then I don't have to tell the sheriff about it. Isn't that a fair reading of the statute?
Well, I think there is a comma in there, and the statute is read in the alternative, that if used for self-identification during internet communication, that it's the bit about...
You're right, I abbreviated it, but it still has that qualification, internet communication or posting for both parts.
Well, but you still have, I mean, okay, maybe if you just sign in for the New York Times, even though I would think that I have a login for my New York Times electronic subscription. So I think that is in fact a designation used for self-identification. That I can give that to my wife and she can log in too, but that's covered, I think. But there's also the fact that there's no denying that if you want to sign into the Iowa City Press Citizen and make a comment about a particular story, that's covered here. That if you, I think the Amazon account is covered. I think that if you sign into Amazon for purposes of the communication that I want to buy something.
We're not talking
That's
about a guy that's in trouble for maybe embezzling or whatever it may be. This guy is on the sex offender registry for a reason. And I haven't heard of too many cases that have to do with a concern about a Hy-Vee fuel card versus Facebook. I think sex offender registry concerns, don't you think they warrant something like Facebook where it's not so much just viewing on Facebook, there's a lot of posting. And isn't that kind of what the statute is geared towards, more so than your example of a Hy-Vee fuel card?
Well, in Packingham, they talked about the fact that the broad restriction was in fact written up contemplating something that was a real concern. And I'm not saying that there can't be a real concern, but when you're dealing with the First Amendment, you got to draw your things carefully. And that maybe I shouldn't talk about Hy-Vee Fuel Saver, maybe I should talk about the Press Citizen, or for that matter, earlier this month, I signed up with the legislature to get a bill tracking system because there's a bill going through about sex offenders in the legislature. I had to log in and create an account in order to be able to get information from the legislature about that particular bill. Maybe Hy-Vee Fuel Saver was in fact a little flip. But the point of the First Amendment is that there's a substantial amount of legitimate and probably not really what the legislature intended to be
Could you elaborate on the chilling effect of merely disclosing to the sheriff the names you might be using on Facebook? How does that have a chilling effect on your free speech rights?
Well, the analogy I used with the district court was that if I had to go down and tell the sheriff every time I logged into the New York Times or picked out a different newspaper to read or to contact, that I might hesitate to do that. I might hesitate not to read that article. I might hesitate before I signed up for the legislative alert. That the point of, and the issue is not whether there isn't a real reason for thinking about sort of who's doing what on the internet. The question is, what's the statute, and does it sweep too broadly?
But I mean, what we're getting at really, I think the concern is sex offenders using pseudonyms. I mean, what would you think of a law that said if you're a sex offender, you don't have to do any of this registration process, but you have to use your true name for any username that you use when you're engaged in internet communications or postings?
Well, Packingham, I think, made reference to the fact that there was nothing that prevented a legislature for, in fact, crafting a narrow bill that would get at the concern for sex offenders or other people trolling the internet to try to contact minors and lure them away. That's not the issue.
Speaking of that, I agree with you that it might be kind of broad, but I also am concerned about making it too narrow and not being able to address the concern raised, obviously, by the legislature. Your example of the Iowa City Press Citizen, I could envision a situation where somebody on the sex offender registry is going to write a letter to the editor as an attempt to maybe communicate with somebody in particular, maybe the subject of a no-contact order, whatever it may be, or on a topic that might be off limits on his terms of registry. I don't know. My point is, I think we could play this game back and forth all day long, but would you agree with me that Facebook, social media, things that can be used, especially with a false name, and have many times been drawn as an example of how a potential victim is found or groomed, is a concern that is being addressed, attempted to be addressed?
Again, one of the reasons I'm using overbreadth as a point is to try to get away from the Facebook specific. I think if you drafted a statute that said that you had to disclose all your social media or chat rooms, for example, that you participated in, particularly if there were minors at those places, but the point of the First Amendment is that if this is overbroad, that's as far as you have to go. If the legislature comes back and drafts something more narrow the next time, then we'll be back and decide whether that was sufficient. But that this sweeps, the district court judge in Alabama that just had the decision in January enjoining the Alabama statute with regard to internet identifiers talked about the fact that this language, for purposes of routing or self-identification, this could cover if you logged in to the use the Wi-Fi system at the McDonald's. That this could cover if you used your girlfriend's cell phone to read an article on the internet, and that's too broad. I might add that remember, Another way this is too broad, for example, is that
How do you distinguish the 10th Circuit decision that upheld Utah's internet identifier disclosure requirement, rejecting a First Amendment challenge?
that was,
Sure.
for one thing,
Shirt left.
7 years before Packingham. I think that the U.S. Supreme Court, I mean, that was a unanimous decision. And granted, it struck down a complete ban, but it talked about the importance to sex offenders still have a right to use the internet. And Lloyd Aschbrenner's crime had nothing to do with the internet. Maybe another way things could be more narrow is that where you have someone who, by chance, has committed an offense using the internet, maybe there's greater justification. I see my time is up. If I could say 1 minute about the question of punitive. I mean, again,
You may sum up, Mr. Mears.
okay, the Iowa Supreme Court, with regard to whether something was punitive or not, wrote about this sort of a year ago in the TH case, that we do think that that same reasoning applies to adults who, and the fact that the scourge or the danger of sex offenders has been so overblown is something that has impact, it seems to me, not only in deciding whether or not the registry in general is punitive, but also what you think about how this kind of internet identifier provision is something that is an exaggeration or sweeps too broadly and should be struck down. I appreciate your time, and it's a challenge sometimes when you're litigating something which involves a national issue, because you're finding there's something new almost every day, and I apologize for the frequency of giving you additional information, but news comes when it does.
Thank you, Mr. Mears. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court. Counsel, good afternoon. It's a privilege to be here. I think this court is on the right track when it comes to the statutory construction issue for the definition of internet identifier. I'd point out that the definition starts by saying an electronic mail address, instant message address or identifier, or any other designation or moniker used for self-identification during internet communication or posting, meaning that it looks like the definition is supposed to be limited to designations or monikers that are like email addresses or instant message identifiers and are being used for communication or posting. I'd suggest that the only gloss that really needs to be put on this at all is to clarify that it's used by the registrant and not used by somebody else to direct a communication at them, like an email subscription or a package from Amazon on its way to a door. That when we talk about email addresses and instant message identifiers being used in internet communication or posting, especially posting being an active, something done by the registrant, that's the target of the registration requirement here. I think that's the appropriate gloss to put on this, which, and I know that the overbreadth type challenge is available. On the other hand, this court does construe statutes to avoid unconstitutionality and to save them wherever possible. I think this definition is susceptible to an interpretation that avoids overbreadth problems and is correctly tailored to the evil or the risk of harm that it's intended to prevent.
What did you make of Judge Maich in his Colorado case, Rankin? And he, paraphrasing a little bit, but he spoke about the role of anonymous speech, actually, and stressed that the First Amendment protects anonymous speech, that powerless people and people who are, you know what he says, the down and out folk ought to have the right of anonymous speech. I think it's fair to say he was a little bit barbed in his analysis of internet identifiers. What's your response?
Well, I think it does pluck at a chord that I think is important, that anonymous speech is something that we value, and that's why I think that intermediate scrutiny is probably the best level of review to apply, because this does look like it implicates the First Amendment protections. On the other hand, there are dangers associated with communications with sex offenders in using anonymity to their advantage. I think we tried to include some of the research on this, that one of the things about the internet is that when it encourages anonymity, it encourages risk-seeking behavior, not only on the part of sex offenders who may be looking to solicit or even interact with minors in ways that are inappropriate that we want to prevent, but also on the part of minors who may find themselves in situations where they're drawn into a real-life interaction that the person then happens to be a sex offender, and if we don't have any system for tracking their activity, or not tracking all of their activity, but allowing a concerned person, whether an adult on behalf of a child or on their own behalf on a dating website or some other social networking, to check on the status of the sex offender registry status associated with the pseudonymous individual behind the avatar that they're communicating with. And I think that anonymous speech can be important. This doesn't prevent the speech in the first place. Anyone on the sex offender registry can still...
Judge Meade sure didn't care for it. Let me ask you another question related to really the first issue, what ex post facto issue. As I think has been correctly pointed out, there's been a run of cases finding that certain SORNA amendments do violate ex post facto, and not so much in the internet identifier, but in-person registration requirements and so forth. There's been a little bit of a trend, I think, in the last couple of years, particularly for state courts. I found 8 or 9 that struck down. And some of them argued that disclosure requirements that are akin to parole or probation really are more punitive in nature. Now here we don't. Here that's not quite what we have. What we have is a internet disclosure requirement. But by analogy to those other cases, and you know which cases I'm talking about. I mean, there's Vermont, and Ohio, and Pennsylvania. You know them all, I'm sure. Although they don't involve internet identifiers, they do involve cases where the supervision is thought to be akin or similar to probation and parole. I think you understand my general concern.
I think so. I would draw some distinctions. Iowa's sex offender registry requirements only require a certain amount of in-person check-ins periodically, once a year for Tier 1. I think Mr. Aschbrenner is Tier 2, subject to twice a year.
I'm going to interrupt you just for a minute, though. I think in this case we're only dealing with the marginal amendment changes. I mean, I think we're invited to focus on the internet identifier. I don't know that we go back and look at other provisions of the statute, or do we? I mean,
Well, I think that the way that I read the challenge was that it was making a broader claim that the entire registry scheme is ex post facto, although I don't know that, in a lot of ways it became less restrictive, less disabling when applied to Mr. Aschbrenner. Specifically, he's no longer subject to any residency requirement. And I think that is illustrative of the fact that this is not intended to impose punishment in a way of righting the moral wrong that's the result of the offense. It's intended as a way of protecting the community, and when the legislature concludes that some measures aren't doing that, they have no hesitation to go back and tinker with that and refine, even if it means making the requirements more lenient in some areas. Now, the way in which and the challenge that I saw Mr. Aschbrenner bringing does focus a little bit on the in-person reporting requirements. I would say that Iowa's are a lot less burdensome, a lot less restrictive than those that have been struck down in other states, especially Michigan. I took a look at the Michigan brief and the statutes referenced there. in-person check-ins required to change basically any relevant information. Whereas with Iowa, only to change residence, employment, and school. Anything else, by department rule, you can call or you can send an email very quickly.
That may be true, but some of the cases talk about check-ins twice and 3 times a year as being equivalent to parole. So I don't know. It seems to me, in fact, there are quite a few. I think there's 4 or 5. Not that the numbers necessarily mean a whole lot, but there's 4 or 5 cases that say that in-person check-in requirements that occur on a regular basis annually. You can go ahead and do it, but you just can't do it retroactively, is basically what I read them saying.
I would reject the comparison or equating these to probation and parole. One of the most important differences is that failing to comply doesn't result in revocation and imposition of a punishment for the prior offense. The failure to comply is just subverting the regulatory and protective measures put in place. Maybe a crime unto itself, but it doesn't trigger imposition of punishment, right? The scheme itself isn't punishment for the offense such that failure to comply results in imposition of punishment for the original offense. I'd also say that the probation and parole schemes go much further than in-person check-ins. There's all sorts of conditions that are applied at discretion of the judge or at the discretion of the department, and they put additional restrictions on conduct, substantive conduct that you don't find in these sex offender registry requirements. Now, there are some restrictions that are related to keeping the community safe, but you don't see anything like no alcohol, no drug use, UA testing, anything like that.
Shouldn't we just focus or the case we need to decide is internet identifiers? We don't need to decide whether other provisions, and in this case, that he can update or disclose his internet identifiers by phone or email to the sheriff.
That's right.
Why shouldn't we extend TH involving juveniles to adult offenders?
Well, I think there's a couple big reasons. The first is that the affirmative disability or restraint being imposed is qualitatively different. In TH, it was recognized that the exclusion zone has an impact on isolating a juvenile sex offender from all of the developmentally important opportunities to interact with their social peer group. That's not something that we have here. Another important point of difference is on the 7th Mendoza-Martinez factor of reasonable in relation to the non-punitive aim to be achieved. Now, TH specifically made its recidivism-related findings in comparative terms, that juveniles are much less likely to recidivate and commit more sex offenses than adult sex offenders are. And even in stating it the way that it's put in TH, I think it makes it very clear why this case is different. Now, I don't think that we need to defend the verbiage from Smith versus Doe that says that recidivism rates can be as high as 80%. In fact, I think the Iowa legislature knows that's not true and has, or knows that that might be an overstatement and has received reports to that effect. But the recidivism rates reflected in the data are frightening enough and high enough, especially in comparison to baselines of Iowans generally and offenders convicted of non-sexual offenses, that it justifies it makes these restrictions reasonable because we've identified a population that has at the very least, quadrupled risk of committing additional sex offenses or future sex offenses that victimize Iowans and create this particularly pernicious harm that is worth protecting against. And I think that I am lowballing the estimate there, saying quadrupled. The Hansen meta-analysis, which is really the only real data cited in that Ellman and Ellman article, apart from the California study about parole, but that's only about parole and doesn't have a very long follow-up. Regardless, the Hansen meta-analysis says it's 11.9%, if I recall correctly, over 8.2 years for all sex offenders generally from low risk to high risk all aggregated together, compared to about a 1.9 to 3, I think maybe 4% for all offenders over a similar period of time, or actually that's over a shorter period of time. And then compared to the baseline, which I provided a quick back of the envelope arithmetic on what that looks like in Iowa, but it's definitely less than 0.01%. For background, the whole population of Iowans committing sex offenses over a year's time, and then, multiplied by the number of years. Suffice to say that the risk of sex offender recidivism is, doesn't need to be 80% to be for these restrictions and registration requirements to be reasonable in light of the
And
non-punitive aim.
how does requiring of sex offenders to disclose and update their internet identifiers help protect the public?
So in two ways. One is that it enables law enforcement to use that information if they need to investigate a crime in progress. If someone goes missing and there's evidence that they've been communicating with somebody on social media, using that information, if that identifier has been used, or if it's similar to another identifier that's been used, that can provide valuable leads. Now, I know that the criticism is no offender will report the identifier that they're going to use to commit a crime, which I think is may or may not be true. They may use a similar pseudonym that can be traced back and compared and give a lead that they may use. And I think that establishes that when when an offender doesn't register their online identifier, there's cause to be concerned that that's something that we would naturally be concerned about, that being the next step, or something that may occur in the future.
I was going to ask you to address some of the things Mr. Mears brought up as examples where it's overbroad. You can take a pick. He listed several. How do you respond to that?
Well, I'd say that, and keeping in line with construing the statute to save it rather than invalidate it, I'd say the designations or monikers would need to be used for self-identification during internet communication or posting. Even the following language is also limited by in internet communications or postings. I think that postings is definitely something that the registrant does. It's a post. Communications, I think we would construe it as communications by the registrant, such that if you're part of a listserv, right? I mean, your email address is disclosed, but if you use a special a login to manage your listserv subscription, that wouldn't need to be disclosed because you're not communicating outwards. You're not posting. If your Amazon login and account name, if you're posting reviews about various items and are creating the opportunity for interaction with people with postings, that's one thing, and that should be something you disclose. If not, if you're just using it to order items, then it seems to fall definitely outside of the area of interest of the statute.
If you have to disclose the name you're using for postings, doesn't that have a chilling effect on free speech?
I'd say, and I see my time's expired, thank you. I'd say much less so than it would. I mean, the fact that it's pseudonymous speech helps a lot here. That if somebody responds and says, I looked and this person's a sex offender, don't listen to anything they say, discard the pseudonym. And you can resume whatever commentary you have about if it's a political issue or whatever issue you're talking about. You can resume that commentary through a different pseudonym, or you can persist with the same pseudonym and let the content that you're providing speak for itself. The First Amendment isn't offended by this measure because it doesn't prevent sex offenders from using the internet like the registration or like the requirement in Packingham, nor does it prevent members of the community from assessing their contributions on their merits or from engaging with them. It just allows members of the community to know whether the person they're engaging with on the internet is a sex offender and to guard against the risk of becoming drawn in and exposing themselves to harm. And I think that if Packingham means, together with its recognition that the internet is so important, has to come a recognition that we need to be able to protect ourselves from potential dangers on the internet, including those presented by sex offenders. Thank you.
Mr. Sloven, thank you as well. Mr. Mears, you may present your rebuttal.
It's bullet point time. Anonymous speech that I cited one of the United States Supreme Court cases that talked about the fact that unanimous speech was a key ingredient in getting this country founded. A good portion of the founding fathers, whenever they would publish something.
That was the McIntyre case, and that was the woman who wanted to put the just the leaflets after the school board meeting on the cars anonymously, and the Supreme Court said that was protected. But generally, when you engage in many forms of political speech in this country, you have to make disclosure. If I wanted to put out a YouTube video supporting Mr. Sloven's campaign for Attorney General someday, let's say I'm not a judge anymore and he's running for Attorney General, I would have to make a disclosure of who I am, exactly what your client is being asked to make here. And that doesn't violate the First Amendment, does it?
The point I was making was that anonymous speech has been something that has been particularly protected under the First Amendment.
But in special circumstances like the McIntyre case, not in the run-of-the-mill situation.
But there is some important principle, however, of the fact that as a citizen, we shouldn't be required to have a list that's maintained by government of, what magazines we subscribe to, what newspapers we get,
But if we interpret the statute as suggested by the state, you would not need to disclose those lists. You wouldn't need to disclose your New York Times subscription, that sort of thing. Just the outbound where you're posting, where you're communicating with others affirmatively, right?
Well, again, you can read it. I just can't see how that reading can be made, given the fact that it says that internet communication or posting, those are the alternative. Internet communication is covered by this. And if I have a sex offender who wants to, sign up with the Press Citizen, I'm going to tell him, I think you have to go down and tell the sheriff that.
I mean, you raise a good general point that in general in this country, we try to preserve the ability of people to kind of live anonymously and blend in and not have their private lives exposed. And I agree with that, and I think that's a good thing about our country. But having said that, once we've already crossed the bridge with this whole sex offender registration program, isn't the internet identifier just a logical add-on in order to make it effective? I mean, what's the purpose of having a sex offender registry where people can look up whether someone is on the registry or not and where they live, if they then can't, if the offender can then use a fake name on the internet and they can't be traced by the public? I mean, doesn't it kind of diminish the effectiveness of the registry?
But none of the internet identifiers in Iowa is available to the public. It's only available to law enforcement.
But if as I understood it, if the public sees an identifier and wants to inquire of the sheriff's office, is this traceable to a sex offender, they can do that.
To a particular person. They're not, the law enforcement doesn't have a database of all of identifiers for all 6,000 sex offenders so that you can go look up Big Bad Wolf and see whether that goes to a particular person. The statute says that you can ask, does Frank down the street, is this his Facebook page? That's all.
I mean, you see my general point. You can certainly quarrel about the reasonableness of sex offender registry, but once you have it, isn't this kind of a logical corollary to make the registry, help make it more effective?
Well, and part of the problem, too, is then maybe the First Amendment only comes in and has an impact on this one part of it. Because the First Amendment probably protects that, but doesn't protect whether or not you have to tell the sheriff about your car. Several other real quick points, because I don't have much time. We did briefly start touching on statistics. The statistics are not just frighteningly high, they are in fact frighteningly low, in the sense what we're talking about is if 10% of sex offenders are going to reoffend, that means 9 out of 10 people that you're subjecting this to aren't going to reoffend. And for someone who is low risk, actually the Iowa statistics were like 4 or 5% reoffending rate in Iowa for sex offenders. That means 19 out of 20 are not going to reoffend. If you were a low risk offender in Iowa, who's been on the registry for 10 years, you are so low that you're lower than the burglar that's getting out who offends 3 or 4%. My goodness, so much that First Amendment, I do think that there is a genuine issue about whether the entire registry, as of the 2009 amendments, has become punitive like TH. And if that's the case, it can't be applied to Mr. Aschbrenner, who was convicted in 2007.
Well, I'm not sure how to analyze this, frankly. I mean, we have the amendments. We have your claim, which focuses primarily, if not exclusively, on this internet identifier issue. We were talking about some of the case law about in-person appearances and so forth. But that's, you didn't get, your client hasn't gotten punched for failure to make an in-person appearance. And we have 2,000-foot rule and all this kind of stuff. But do we consider parts of the statute that did not take effect until I mean, we don't consider parts of the statute that took effect prior to your client's problems with the law, do we?
Not under an ex post facto
Okay.
analysis.
All right. And do we take into account the registration features of the statute, for example, when your claim is primarily or exclusively maybe, the internet?
Well, my claim is exclusively the internet because that certainly was the direction that we immediately got started on today.
Oh, that could be in a discussion, but I want to know exactly, I mean, why your ox is being gored, and I take it it's just the internet problem.
I tried to present two different and distinct arguments. One is the First
I
Amendment.
understand that, ex post facto and First
And
Amendment.
the ex post facto argument was that this 2009 amendment passed after he had already been convicted, as a totality is punitive just like TH. And that for that reason, whether the internet identifier survives or not under the First Amendment, it can still present problems applying it retroactively.
Thank you, Mr. Mears. Mr. Sloven, thank you again. The case of State versus Aschbrenner is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.